Karen, good morning. Morning, Leslie. Morning, Marnie.
Good morning, Britt. Thank you.
Sure.
And, actually, hello, everybody. I'm so glad we are all alive and well today.
No kidding.
Kieran, while we're waiting for 2 minutes or whatever, you mentioned at the city council meeting about Rio Park.
Yes.
And I don't know anything about Rio Park.
Okay. Rio Park is along the Carmel River behind the mission and the baseball field. And it is an area that was purchased to become a city park. To probably fill you in a little more. And there were plans years ago to develop it as a city park. It would have given a riparian experience to the city. The plans were never developed, and it has become a corporation yard full of wood chips and logs and other things. And I hope that someday we can actually have the vision that I believe Ken White was very supportive of during his term of office come to reality. My son was about 5 years old when I thought it would become a park, and now he's 36.
Yeah, Linda, we bought it in 1986. I'd be happy to give you a field trip down there. And council member, I'm happy to take you down there as well. We've been working with Congressman Farr about the Carmel Area Wastewater District on a potential trail network. So again, happy to take you down there anytime.
Yeah, no, I think there'd be some interest. I think a lot of people aren't aware of it. So anyway, thank you.
Good morning, everyone. It's Britt. Welcome. I'm going to just confirm with our IT department just to make sure that we're good for the live meeting. So if you just bear with us for a minute. Okay, I've just been given the good to go. So good morning, everyone. Thank you so much for joining us. We've got Tom Brown from the City Attorney's Office who will be giving us the Brown Act overview and training this morning. There will be times for question and answers throughout, I believe, right, Tom? People can ask questions throughout?
Yeah, I'm here as long as you need it. If there's a point when I need the question to wait, I'll suggest that while I'm giving my comments, but I'm fine with interactive stuff. It's a long presentation, so we'll also have to be sort of mindful of that as we go through it.
Right. Okay, so with that, I think if you're ready, Tom, unless you want to wait just a few more minutes, there's 24 people here. I think that's about what I had heard from as far as people who could attend the training today. The greatest thing about this is it is being broadcast through the city's website, which means it'll be available after, just like our commission and board and city council meetings are. So it will be available for those who could not attend today. And then it's also available on our YouTube channel. So with that, I will get the presentation queued up and let Tom start speaking.
Sounds good. Thank you, Britt. Good morning, everybody. My name is Tom Brown. I work with your city attorney, Brian Pierrick, through our law firm, Burke, Williams, and Sorensen. I gave this presentation last year, about a year and 2 months ago, and that was fun. It has changed a bit, as all of you are aware, most prominently, I think, with respect to the COVID virtual meeting requirements that we're all dealing with. Britt, I can't see my presentation.
I was just giving a couple of minutes, or a couple of seconds. As we're admitting people, unfortunately, I cannot see my screen once I'm presenting. So if you see kind of something weird show up, just give me a second and I'll go back. But I am about to present right now.
I will defer to you on when the best time is to get going.
All right, you should be good to go.
There it is. So this is the title. Next slide, please. What we will cover today, the lion's share of it will be in the first bullet point here, General Brown Act principles and requirements. I'm going to get in very, very briefly and superficially to the concept of COVID-19 exceptions and procedures for open meetings. And finally, I'm going to get into the new social media law. Britt, something went off. There we go. Next slide, please. The Brown Act starts with a statement of its legislative intent. It's pretty intuitive. Public commissions, boards, councils, and other public agencies exist to aid in the conduct of the people's business. It's the intent of the law that their actions be taken openly and that their deliberations be conducted openly. Next slide, please. The basic rule of the Brown Act, and the Brown Act has grown over the years. It was first enacted in the 1950s. It was not my doing. I wasn't born. But the basic rule is right here in this slide. All meetings of the legislative body of a local agency shall be open and public, and persons shall be permitted to attend any meeting of the legislative body, except as otherwise provided in the Brown Act. We have highlighted here the words that I will be covering because they have their own statutory definitions in some cases, and there are lawsuits and nuances associated with all of them. Next slide, please. The Brown Act is not only a statute in California, it is recognized in the California Constitution. It was adopted into the California Constitution in 2004. Many of you will remember that. There is an open question as to whether the constitutionalization of the Brown Act, in fact, had any legal significance or fact. I'm litigating that very issue right now for a Southern California city. It's my view that while there is no independent requirement that the California Constitution imposes in addition to what the Brown Act imposes on us, it certainly gives us all the sense that the people in the state take the Brown Act and open government quite seriously. Next slide. What bodies are covered? Well, meetings of the legislative body of a local agency. All cities are local agencies within that definition in the Brown Act. Next slide. It is also applicable to legislative bodies, and you may ask what that is. Clearly, it is every city council. It is every appointed city commission and committee, whether permanent or temporary, decision-making or advisory, that is created by formal act by the legislative body. So when you have created your subordinate boards and commissions, your planning commission, your design commission, whatever, those become subject to the Brown Act and must satisfy all the requirements of that. Something that I'm sure you've been told, but some people still don't quite remember, is that newly elected members of a city council, in this case, become immediately subject to the Brown Act's requirements prior to being sworn into office. It raises some head-scratching problems that we will, I think, are in play and open for those of us who litigate Brown Act cases. But I think for your purposes, those of you who are elected city council members, it's important just to remember, conform your conduct to the Brown Act to the extent you can. And if you don't know what that means, contact the city attorney during that interim period between election night and the night you're sworn in. Next slide. There is what many people know of as the ad hoc advisory committee exception. The Brown Act never uses the term ad hoc, by the way, but people understand this in that manner. It exempts from the Brown Act all committees that are established by a city council, a legislative body, that meets all of the following: is advisory only and not decision-making, includes only council members. It includes less than a quorum of the city council. It does not have continuing subject matter jurisdiction, and it is not meeting on a fixed schedule set by the board. Next slide. So briefly, what that means is that if you as a council want to establish a subcommittee of the council, that's fine, and it won't be subject to the council, to the Brown Act, as long as it is truly functioning in an ad hoc capacity. What does that mean? It means that it's only existing for a single purpose, a single issue that is not ongoing, and is only very brief in duration. You know, a month or two, something like that would be what the Brown Act envisions here. Okay, what is a meeting? Well, the definition under the Brown Act is that a meeting includes any gathering of a majority of the members of a legislative body at the same time and location to hear, discuss, deliberate, or take action upon any item which is within that board's subject matter jurisdiction. That's a mouthful. This provision was revised by the state legislature a few years ago when a court case came down and said a meeting is only a meeting if an action is taken. That's not the law under the Brown Act anymore. A majority may not meet simply to discuss or listen. You can't do it all at one time or at one place unless you are otherwise satisfying the Brown Act's requirements. Next slide, please. Okay, the Brown Act says that you have regular meetings and you have special meetings. It also says you can have emergency meetings, and now it allows us to have teleconferenced virtual meetings. But regular meetings of the legislative body, excluding advisory committees and standing committees, must be held at a time and place set by ordinance, resolution, or bylaws. And I know that you as a city have established a regular time and place for your regular meetings. Next slide. The Brown Act then also allows you to have special meetings. That is a meeting to deal with often single issues or one or two issues that come up in between or require in between your regular meetings or otherwise require special attention or more time. The presiding officer or a majority of the legislative body can call a special meeting. Notice is less than it is for a regular meeting. You're only required to give 24 hours notice before the special meeting, but only the business set forth in the notice may be considered at the special meeting. Next slide. Note that after the financial scandal involving the city of Bell several years ago, the Brown Act was amended to prohibit local agencies from calling a special meeting about local agency executives' salary schedule, or fringe benefits. You can call a special meeting to talk about the budget, but many of you may remember that in the city of Bell scandal, a lot of the executive pay was set at special meetings. Next slide. The Brown Act also allows for emergency meetings. You can determine under certain specified circumstances under the Brown Act that I'm not going to go into in too much detail. I think that it's fair to say that you'll know an emergency when you see it. Next slide, please. The Brown Act allows for teleconferencing. Now, we all know that because we're all teleconferencing this morning. Under normal circumstances, when we're not dealing with COVID, totally virtual meetings, the Brown Act allows for some teleconferencing, but it's limited. The meetings can be conducted by teleconferencing, which is any electronic audio or video connection, but you have to meet certain specified rules. The legislative body has to approve the use. The agenda has to be posted at all teleconferencing locations and specify all teleconference locations being used. So, often I've seen it come up where council members have said to me, I'm going to be on a cruise and I want to participate in a council meeting. We've got an important public hearing. We're setting budget. We're doing something that my constituents want me there for. May I do that? The answer comes from the next bullet point here, which is the Brown Act says you cannot do it. You may not do it unless there is public access to the teleconference locations. So I think it's fair to say that if you're on a cruise ship, the public can't have access to your suite or your berth on the ship. Many times, however, I've had situations where council members have been on vacation in areas around the United States, and we have assisted them and advised that they find a public space in the hotel, not the hotel room, because that's going to be very difficult for the public to get up to your room. But you can do it in a public space in a hotel. You need to, believe it or not, post the agenda on that public space. You have to wonder how many members of your constituency will show up when you're in New Jersey and come to that site, but this is what the legislature has imposed. And there has to be a public opportunity for the public to speak at each teleconference location. I've been doing this for a long time. I've never once seen any member of the public seek to speak at a teleconference remote location, but that is the law in any event. Next slide. The Brown Act allows for offsite meetings under narrow circumstances. A meeting may be held offsite to inspect real or personal property that cannot be conveniently brought into the agency, to participate in a multi-agency meeting, or in an emergency for reasons of safety. Next slide. Informal meetings. This is language, this cautionary language appears in the Brown Act. It says, a majority of the members of a legislative body shall not use a series of communications of any kind, directly or through intermediaries. 3, to discuss, deliberate, or take action on any item of business. 4, that is within the subject matter jurisdiction of the body. This is the famous serial meeting that we've all, I think, gotten familiar with over the years. Next slide. Serial meetings typically take the form, although now they've evolved a little bit, but they take two forms. One is called the daisy chain. That is where council member A contacts council member B, and member B contacts member C, and so on until a majority or quorum has been involved. This kind of a serial meeting, this slide says may result in a violation. I will say most of the time will be a violation. Next slide. The next kind of serial meeting that is prohibited by the Brown Act is what's known as a hub and spoke meeting. An intermediary is used. So, for example, you may have a neighbor who is interested in a land use application that you have, and council member A talks to that neighbor, who then talks to council member B and council member C, and so That is the so-called hub and spoke. It violates the Brown Act. It's a serial meeting. You may not do it. Next slide. All right. So in the era of Facebook and all our other social media platforms, this too can violate the Brown Act if you are, for example, as a majority of the council, all on one page or one site regularly, and you are effectively communicating with one another. Now that can be done with the like icon or the dislike icon or the celebratory fireworks in response to something. I would be aware of that. I'm going to get to the fact that SB 992, recently enacted, addresses this specifically, and I'll talk about that at the end of my talk this morning. But be aware, I think, that the use of email and other technology can violate the Brown Act. Next slide, please. Email. I think we've all gotten pretty savvy with email, but here are the recommendations. Avoid sending emails to the entire legislative body. It's something that may be done by your staff under limited circumstances that are done, I assure you, typically in consultation with your city attorney. But you should avoid sending emails to the entire legislative body. If you have to provide information only, don't solicit a response from your colleagues. That's looking an awful lot like a deliberation. By the way, these recommendations are not just in the context of the Brown Act, but often when you're acting as judges, when you're acting in what they call an adjudicatory capacity, making a decision on certain adjudicatory things like use permits or subdivisions or lot line adjustments or whatever else you have under your code that requires a hearing, then certain due process rules apply. And all of these kinds of contacts can also be problematic. And I know, for example, that the city of Carmel has what's known as an ex parte communication prohibition. And that's typically, that's something that not all cities do, but it's a good caution. It's a good cautionary approach to adjudicatory decision-making. It essentially says, don't talk to people outside of the noticed public hearing about the issues that you will be talking about during the public hearing. These kinds of contacts can implicate both the Brown Act and these due process considerations. Back to emails, be careful replying to emails. Don't hit reply all if you can avoid it. That opens up a real can of worms. I've litigated these cases. They're tough to win. And by the way, if you don't believe that they happen, change your mind about that. These kinds of lawsuits do happen. The open government advocates are everywhere, and if they're not paying attention to you, one of your constituents will get their attention at some time, and they are knowledgeable and passionate about open government. Be careful about replying to emails. Don't communicate your position or make a commitment in an email. Generally, both in emails and in your conversations with folks, now that you're on the council, the really, I think, conservative and cautious approach is to tell people, look, I have real concerns about this issue, but I'm going to keep my mind open, and I'm not going to make a final decision until I've heard everything at a public hearing, at the open meeting. And let me just say as well that as you send emails, I think we all kind of can get into a mindset of thinking we're invisible with our emails. And I can assure you that when the email is on the front page of the local paper, and I've dealt with that with several cities, it's really, really uncomfortable, and any explanation will look, frankly, lame. Next slide, please. Okay, the Brown Act specifies a variety of different situations that it determines are not meetings subject to its requirements. One is an employee or an official of a local agency may engage in separate conversations or communications outside of a meeting in order to answer questions or provide information, so long as that person does not communicate to members of the legislative body the comments or positions of any other member or members. You know what this is? This is the city manager briefing. In almost every city I work with, city managers brief their council members, but they're very careful about not trying to find out who's voting what way or what people's feelings are, but they're letting their council members know what's going on in the community. The Brown Act says that's okay, whether that's from the city manager or your planning director or your police chief, whatever. Those kinds of communications are fine. Next slide. The Brown Act also recognizes that individual contacts or conversations between a council member and any other person, provided that that person is not serving as an intermediary between other members of the council, that's okay. You can meet with constituents individually. You can meet with one after the other, and they can meet with all 5 of you. What you cannot do is have a conversation that says, how is Mary voting? How is Joe voting? Here's what I think. Tell Joe that. Those kinds of conversations are not okay, but it is okay for constituents, even stakeholders in disputes, to meet with their individual elected officials, and all of you. And the Brown Act says that is not a meeting. But again, be careful not to be, effectively using those contacts as a way to communicate and deliberate with your elected colleagues. Next slide, please. There are a variety of different, what I call the sort of ceremonial or conference exceptions under the Brown Act. One is for a conference that's related to the business of the agency that is open to the public. This is important. And all of these have the same caveat or the same qualifying limitation. And that is, even when you go to a conference like this and all 5 of you are there, you may not talk about the city's business at that conference. And I would say that just sort of a good practice suggestion is that to the extent you can, you might want to sit apart from one another. Because often at these conferences, you'll see the editor of the local paper and he'll see you, or she will see you there, and there is something of an appearance issue. That obviously is not legal advice, and I'll leave it to you to decide for yourselves what the best practical advice is there. Next slide, please. Similarly, if a majority of the members of the council attend an open and publicized meeting organized to address a topic of local community concern by a person or organization other than the local agency. Look at the highlighted term, open and publicized. How many of you think that if some neighbors are getting together and they want to talk about an issue of concern, maybe an upcoming land use matter, but they're not letting everybody in. They don't want their neighbors who are in support of the project, and maybe they don't want the council member who disagrees with them at that meeting. I don't think any of us believes that's an open and publicized meeting. We don't know, by the way, what publicized means in this context. Does that mean that somebody has to do what we do, which is posting agendas around town, flyers on phone, on phone standards? And I'm not sure what publicized means, and there is no litigation or case law on that point. But in any event, you can attend that meeting if it's open to everybody and if everybody effectively knows about it. Again, you can't talk together at that meeting about the city's business. Next slide, please. You can also attend an open and publicized meeting of another body of the local agency. That means you can go to the planning commission meeting. Again, provided you don't talk about city business together when you're there. Next slide. And you can attend a purely social or ceremonial occasion or event. Again, don't talk about city business over the eggnog bowl. Next slide, please. Attendance at an open and notice meeting of a standing committee of the body. Now, remember that I talked before about standing committees will be subject to the Brown Act. Those are agendized and open to the public because they are not ad hoc, they're not limited in duration and subject matter, they're standing and they're ongoing. You can go to that. Your elected council may attend that, a majority of you. You have to only attend as observers, however. That's what the legislature has imposed on you. Next slide, please. Okay, moving to agendas. The Brown Act tells us that meetings have to be open and public. I think the learning over the years has been that an open and public meeting is of no use unless people know about it. And so the agenda requirement in the Brown Act has been created to allow for your constituents, your public, to understand what will be happening at your meetings and to decide whether it's important enough for them to take the time to attend. I'm going to talk quickly about agenda posting requirements, agenda description requirements, public comment, non-agendized items, and adding items to the agenda. Next slide, please. A written agenda must be prepared for each regular or adjourned regular meeting of each legislative body. We all know that. We're used to that. The agenda for a regular meeting must be posted at least 3 days, 72 hours before the meeting. Most cities in California are typically Monday or Tuesday night meetings, not all. What night do you all do your meetings? Anybody there? Hey, Chip, what night do you do your meeting?
We have special meetings. It's actually codified. We have our regular meetings the first Tuesday.
Yeah.
And then we use Monday as a special meeting for closed session and sometimes for overflow items or presentations or the consent agenda.
So in meeting the 72 hours, you then typically will get your agendas out when? 72 hours before, or like the Wednesday or Thursday before?
Yeah, our goal is to publish the previous Wednesday.
Yeah. I've seen cities now that in trying to be customer friendly have gone even a week before that. But most cities will adhere to the 72-hour rule. Notice of all the meetings have to be posted on the agency's website if the agency has one. There aren't many that don't have them anymore. Next slide. The agenda description, each item of business to be transacted or discussed, including items to be discussed in closed session, must be the subject of what the Brown Act calls a brief general description. And the Brown Act says that description generally need not exceed 20 words. Here's the deal. It used to be, and there still are some cities that haven't quite understood this, that insufficient care went into drafting the agenda. And what you would often see would be agenda item 1, contract CM3-4256. And that would be it. That's not enough to apprise the public, to let somebody know when they're sitting at home, do I want to go and weigh in to my council? Do I want to weigh in or even listen to what they're doing? Something more needs to be done. I'm sure, in fact, I've looked at your agendas and they're very good, that your city clerk is tuned into that necessity, which is try and have your agendas be meaningful to your public. Try and think, look at this through the lens of, if I'm at home, how am I going to understand whether I want to weigh in on this? The other point here is that every individual decision that you will be making ought to be on that agenda. There was some case law a few years ago where some minor and what I would call ancillary contracts, as well as an EIR decision, were to be made and were in the staff report, but were not on the agenda. And the courts of appeal in those cases invalidated those decisions. we don't want to be in that position. We want to be making decisions that can't be invalidated. So think about that, the importance of the agenda. Next slide, please. Non-agendized items. Action or discussion on any item that is not on your agenda is prohibited. That's been clear in the Brown Act for a long time. The Brown Act does say that council members may briefly respond to public statements or questions, ask a question for clarification, make a brief announcement, make a brief report on his or her activities, provide a reference to staff for other sources of factual information, or request staff to report back to the council in a subsequent meeting. And you can always direct staff to agendize something on a future agenda. Now, this is not carte blanche for these exceptions are not carte blanche for council members to engage in long discussions or long reports about what you're doing. If you are planning as a council to have all of you give reports on what you're doing, what you're noticing in the community, for gosh sake, agendize it. Have your clerk just put something on your agenda, either on a one-time basis or as an ongoing matter, such that council members can report out. What is briefly respond to public statements or questions? I litigated that issue for a Southern California city several years ago, and believe it or not, the city got sued where the total conversation in response to a question from a constituent in the public was about 6 minutes, 10 seconds. And the local advocates for open government thought that was not brief enough and that should have been agendized. We won that case, but I can tell you that that's not a bright line rule. And it's, I think, very important to bear in mind that as you are responding to the public at a meeting, be very brief and just say, look, we ought to talk about this more at a future meeting. Let's get this agendized, Madam or Mr. City Manager. Next slide, please. Adding items to an agenda, the Brown Act has very limited means for doing that, where something comes up at a meeting and you need to deal with it. One is that when the majority of your council decides that there's an emergency. The Brown Act defines that as a work stoppage or a crippling disaster. I think we can all get that ought to be sparingly used. The Brown Act also says that where 2/3 of the council or unanimous council of less than 2/3 are present, determine two things: that there is a subsequent need to take immediate action, one, and two, that the need for action came to the attention of the local agency subsequent to the agenda being posted. Here's the deal. Forgetting to put something on the agenda does not satisfy that. You cannot do it. It's also where you decide we need to get something done in a hurry and it'll be advantageous to us to do it in a hurry. That's not enough. There needs to be truly a situation where if the city didn't know about it and could not have known about it at the time the agenda was posted, and something really bad is going to happen if you don't act immediately, you can't do it otherwise. Next slide. We're going to talk now about public access to meetings, physical accessibility, meeting documents, recording of meetings, the right to record, public participation, and limits on public participation. Next slide, please. Accessibility. Members of the public are allowed to be anonymous. They cannot be required to register their names, provide other information, complete a questionnaire, or otherwise fulfill any condition precedent to attending a meeting. Many cities, I don't know if you folks do, but many cities require folks to fill out a speaker form. That's okay. What you can't do is say you can't speak unless you fill one out. So if somebody says, I'd rather be anonymous, they have that right. No meeting or any other function can be held in a facility that prohibits attendance based on race, religious creed, color, national origin, ancestry, or sex, or which is inaccessible to the disabled. I don't know whether I've seen it happen. Frankly, I haven't seen any facilities that prohibit attendance based on those protected classifications. But I have seen situations, for example, for cities that had their council meetings on the second floor of an older building, and the elevator went out. And I think it's fair to say that that's not physically accessible to the disabled. Discussions could be had as to whether you can create a television, a remote room for folks who are disabled. I think the better answer to that is no, and you can't do it. Next slide, please. Accessibility for the disabled. Meetings must be held in facilities accessible to the disabled. As I said, agendas must include information regarding contact information for requests for disability-related accommodations. And agendas and other documents must be made available in appropriate alternative formats when requested. Coordinate with your city clerk on this. She's, I'm sure, very well aware of these requirements. Next slide. Meeting documents. The public has a right to review agendas and other writings that are distributed to the majority of the legislative body, except for privileged documents. Obviously, if your city attorney is giving you privileged attorney-client advice in writing, the public's not allowed to see that. There have been many cases that have recognized that when I give you advice, I'm entitled to give that advice confidentiality, because you are entitled to a lawyer, just to the same extent as any other private person or litigant is entitled to be represented by counsel. But writings must be made otherwise public, and they have to be made available at the time they are distributed to the majority of the legislative body, and that is before or at the meeting, if they're prepared by the agency or a member of the legislative body. Or otherwise, the writings have to be made public after the meeting if prepared by some other person. So if you have a member of the public coming out and distributing pictures or letters or something at the meeting, the city is not bound, you're not bound to immediately copy those documents and make those available at that time, but you need to make them available as quickly as reasonably possible after the meeting. Can you do better? If you have a practice of sending someone, you have an available copy machine available, and you do that, nothing in the Brown Act prohibits you from being more transparent or open. Next slide. Recordings of meetings. Any tape or film record of a public meeting made by or at the direction of the agency is subject to inspection under the Public Records Act, the other principal transparent open government statute in California. However, it may be erased or destroyed 30 days after the recording. Any inspection of a video or tape recording is to be provided without charge on a video or tape player made available by the city. The agency may impose its ordinary charge for copies of the video. Next slide, please. This used to be a bigger deal than it is now with iPhones, but it used to be that some folks would come in with the kind of big camera equipment that you would see, that required big lighting and like that. But the Brown Act says from way back then, the public is allowed to use audio or video tape recorders or still or motion picture cameras at an open meeting, absent a reasonable finding that doing so would persistently disrupt the proceeding due to noise, illumination, or obstruction of view. That's still the rule. Somebody can't stand in front of the meeting blocking it to make an audio or video recording, but folks do have a right to record. And now the equipment is so advanced that I really can't envision many circumstances under which this is going to come into play. The fact that you don't want to be recorded privately or by a member of the public on their iPhone is of no legal significance. The law allows them to do it. Next slide, please. Public participation. A regular meeting agenda must allow an opportunity for members of the public to speak on any item of interest, anything. So as long as the item is within the subject matter jurisdiction of the city. What does that mean? I've taken the position in my city attorney capacity over the years that cities have incredibly broad subject matter jurisdiction. There is very little that's not within your subject matter jurisdiction. Areas that really sort of come into dispute under this provision is whether folks can come in and talk about their desire to elect someone to a state office, not affiliated directly with the city. I can tell you that those are tough lawsuits to win. If you get sued by an open government advocate, I think you're better off using your time limits to avoid that, rather than trying to tell somebody what you're talking about is not within our subject matter jurisdiction. So typically this first bullet point is addressed in what most cities have by way of what's called public comment or open forum. And there's usually a time, most cities do it at the outset of their meetings, where the public can come in and talk about any non-agendized item. They can talk about anything they want to talk about. The second bullet point is that the public must be allowed to speak on any specific item of business, anything you have on your agenda, in other words, before or during the legislative body's consideration of it. So typically at a public hearing, that happens where you'll have an agendized, city council consideration of conditional use permit for property located at blank. The public typically is allowed to come in and weigh in on that item at the outset of the item. There are also, as I said before, when you're acting as a judge, there are due process reasons why that needs to happen at the outset of the hearing. I think that it does not satisfy this provision to force people to speak to the item at some point after the city council has already heard all the other evidence or has already made or announced its decision. I think that to satisfy this, you really need to allow people to say it at the outset or after a staff presentation. And then finally, the third bullet point, public comments at a special meeting may be limited to the agenda items only. In other words, the Brown Act does not require that there be open forum at a special meeting. Next slide, please. Limits on public participation. The legislative body, the city council, may adopt reasonable regulations, including time limits on public comments. In other words, you can limit every speaker to 3 minutes. I'm assuming you do that in Carmel. That's my recollection. I don't know any cities that don't. Chip, is that the case? Brett, what do you impose in terms of time limit?
Depending on how intensive the item is, Mr. Brown, we start with 3 minutes, and then again, if there's a slew of speakers, we ask that they keep their comments short. Sometimes the mayor will reduce it to 2 minutes with the rest of the council's approval. The mayor, who's been in office been in local government for a long, several decades, will often say, hey, if you agree with the previous speaker, just say I, agree. There's no, you're not obligated to repeat the same thing over and over again. So, but 3 minutes is where we start, sir.
Yeah, good. Thank you. This is a heavily litigated, believe it or not, provision in the law. And here's where it gets litigated. One is where the city council listens to people it likes. It listens to its friends. or the people who are very supportive of the council's mission. And those people will say, hey, I just have another couple minutes. You mind if I go a little further? And they say, of course, go ahead, take as much time as you want. And then later in the meeting, or 90 seconds later, someone comes up who is opposed to what the council is doing, or is critical of staff and the council, and they want another 2 minutes to go on, and it's painful, and it's burning the skin off your face to listen to what they're saying. And I've been through this for 40 years, and believe me, I've seen some very angry constituents out there. Here's the deal. I'm litigating cases now. I've litigated them for years. You have to apply these time limits uniformly and equally. You have to apply them the same way to everybody. Otherwise, you can't enforce them at all, and you will get sued in federal court for civil rights violations for violating their civil rights and their First Amendment right. So it's not just the Brown Act here, it's also the Constitution that you have to be cognizant of. Be careful of it. Also, you have a right to run your meetings. The mayor or your council, you can interrupt people. There's no constitutional violation in simply interrupting or asking questions or requiring a speaker to stay on topic or whatever like that. What you can't do is cut someone off and prevent them from speaking altogether. And especially you can't do it if it's viewpoint responsive. In other words, if you are limiting someone or interrupting somebody repeatedly such that their time is cut off solely because of something they've said. Next slide, please. So if somebody gets unruly and disruptive, the council may remove that person from a meeting if they are willfully interrupting the proceedings. The council may also clear a room if order cannot be restored by removing people. Note that members of the news media who have not participated in any disturbance must be allowed to continue to attend the meeting. Again, be very cognizant of the fact that what you think is disruption may just mean that someone is raising their voice to express their indignation with your policies or their criticisms of your policies. Under the Brown Act, they have a right to do that. Next slide. Expressions of support or opposition to matters before the legislative body, provided they're not disruptive. Someone can't be screaming to a point where it's hurting someone's ears, or they're refusing to leave the lectern after their 3 minutes have lapsed. But merely expressing in a vehement way support or opposition is protected speech, and they have a right to give it. And the legislative body under the Brown Act and under the First Amendment cannot prohibit public criticism of policies, procedures, programs, or services of the agency. Next slide. Voting disclosure. The Brown Act has been amended again and again over the years to make sure that the public gets to know how its individual elected officials are voting and its appointed officials. Legislative bodies must publicly report any action taken and the vote or abstention on each action taken by each member present. Most cities are doing roll calls. Some have lighting that shows the individual votes. Either is okay in that situation. Next slide. Sometimes cities will take action other than by a roll call vote. I've seen it, for example, where councils use written ballots for the appointment of some of their subordinate boards and commissions. That's fine to use those ballots. The Brown Act says you may not use a secret ballot, but you can use the ballot as long as at the end of the voting, each individual council member's vote is announced. In other words, it doesn't have to be that while you're doing that balloting, the disclosure has to happen immediately, but ultimately the vote for an action taken has to be disclosed as to each individual member. Next slide. The Brown Act does allow for closed sessions. It allows and typically this is only the city council, and we wouldn't be for your subordinate appointed boards and commissions. Closed sessions are an exception to the rule that agency meetings must be open and public. Only topics authorized under the Brown Act may be discussed in closed session. The most common closed session topics are personnel matters, litigation, real estate negotiations, and labor negotiations. And the courts have said again and again that, for example, were a city council to have to conduct its real estate negotiations or its litigation negotiations or discussions in public, there would never be a case where an agency didn't pay the highest possible price for a piece of property. So you're allowed to talk, to go into closed session. There are strict limits on it, however, in terms of both noticing and in terms of what the council is allowed to talk about in closed session. For example, real estate negotiations, the council's only allowed to talk about price and terms of payment. There are a lot of litigation over the years that say that ancillary discussions about, well, would this be a good land use, or would this property be, how does it play in with our redevelopment efforts like that? That's verboten. That's not okay. Also, there are limits under the Brown Act with respect to, for example, personnel matters, whether salary or new contracts for your executives, for example, may be discussed. They may not. However, some of those discussions may take place under the separate labor negotiation heading. I will say that the Brown Act a few years ago, adopted a template for proper closed session agenda descriptions. And typically, if you satisfy that, if you use the legislature's template, you will satisfy the Brown Act's requirement for noticing a closed session. Next slide, please. Prior to holding the closed session, the legislative body has to disclose the item or items to be discussed. Typically, that's done where you convene into open session and announce that, either read the items on the agenda or announce that the council will be convening into closed session to discuss each of the items on the posted agenda. Note that the public has a right to address the legislative body on closed session items before the council goes into closed session. Next slide, please. Typically, after the closed session, the council must reconvene to report on any final action taken. Oftentimes, there is no final action taken. In fact, most of the time, there is no final action taken in closed session because another party must approve or ratify some agreement, whether that is an employment agreement, a settlement agreement, a real estate agreement. Typically, those are not considered to be final for purposes of reporting out, but not always. And often there have been many occasions when I've come out with a council and the mayor or I will report specifically what action was taken in closed session. Finally, once final approval occurs, related documents are public records and they must be disclosed openly upon request. I typically, over the years, whenever I'm negotiating settlements of litigation, for example, I make clear and I insist on a provision in the settlement agreement where my opponent says, this will be a public document and the city will be required to disclose it. In many, many instances, opposing counsel and the city's adversary in litigation will ask that the litigation settlement be confidential, and I will tell them emphatically and unequivocally, no, this is required to be a public record. Next slide. Disclosure of closed session information. What happens in closed session, much like what happens in Las Vegas, stays in closed session. These are confidential sessions by statute. You are often receiving you're always receiving confidential information that is sensitive. It will either relate to someone's personnel matters, or it will relate to litigation or some other matter that the legislature has deemed to be confidential. For that reason, the legislature has said that council members they are prohibited from disclosing information received or learned in a closed session outside of the closed session. Now, that can be waived by the city council if the city council deems some information received in closed session to be important enough to the public to be disclosed. The full council has the authority to make that decision. Next slide. Legal challenges. So we all do our best to comply with the Brown Act to satisfy all of its many requirements, and there are many. But I can assure you that in some instances, some people will accuse you of not living up to those requirements. And the Brown Act recognizes that they may do that, and they may do that by filing lawsuits against you. So there can be legal challenges brought under the Brown Act. I'm going to talk about pre-litigation requirements. There are requirements for that anyone who wants to sue you has to make a request to cure or a request that you cease and desist the violations. If that doesn't work, they're allowed to bring civil actions, a variety of different ones specified under the Brown Act. And if they win, they can recover their costs and their attorney's fees. Next slide. So the first, the kinds of lawsuits that can be brought, there are civil actions, and there is also the potential for criminal liability for Brown Act violations. However, I can tell you, I've never, in 40 years of representing cities, I've never seen anyone prosecuted criminally for a Brown Act violation, or at least successfully. But in civil actions, a district attorney or any interested person, that's anyone, they don't have to live in your community, can file a civil action asking a court to stop or prevent violations or threaten violations of the Brown Act, to determine the applicability of the Brown Act to some of your past actions and or threatened future actions. And they can seek to void certain past actions that they claim were made in violation of the Brown Act. Pretty broad ability to go after you for violations. Next slide. In some cases, before filing an action to void for what's called a nullification action, to void certain past actions, the party who claims to be aggrieved must send the city a written cure or correct demand. The demand has to clearly describe the challenge action, the nature of the violation, and the cure sought. And it has to be sent within a specified period of time, 90 days or 30 days, depending on what kind of action. The legislative body, the city, then has up to 30 days to cure. If it doesn't, a lawsuit has to be brought within 15 days of the lapse of its time to act. This is what's called a statute of limitations on these kinds of lawsuits. Next slide. Different kind of lawsuit under a different section of the Brown Act will allow someone to sue you not to nullify an action, but to get the city to stop, to cease and desist what it's been doing allegedly in violation of the Brown Act. Before some of these lawsuits, not unlike the cure and correct letter requirement, the Brown Act requires that the person challenging what the city's been doing submit a written cease and desist demand letter. Again, here, the letter has to clearly describe the violation, and it has to be sent within a certain time period. The city then has a specified period, 30 days, to issue what the Brown Act calls an unconditional commitment to cease and desist. That's the sort of surrender Dorothy letter, and the response saying, yeah, hands up, we give up. If the city doesn't give that unconditional commitment, that's when the lawsuit gets filed. And next slide, please. Invalidation actions, what I was calling the nullification action, is limited to specific statutory violations under the Brown Act. The cease and desist kind of lawsuit can go to any Brown Act violation, but the nullification, if someone wants to nullify a specific action, an approval of a project, an approval of a big contract, whatever, it has to be limited to the following. Violation of the basic open meeting provision, violation of the notice and agenda requirements for regular meetings and closed sessions, and for tax hearings and special meetings. Note, as I said before, the Brown Act has a template for closed session agendas, and it specifically says that there won't be any liability if you follow that. That's a little bit misleading. It's not quite as much of a immunity cape as you would think in litigation under the case law. Next slide, please. Costs and attorney's fees. Brown Act litigation is risky, not just because it can look bad in the public if you have been violating and if there is a judgment against you for violations of the Brown Act, but because it can be very expensive. If you lose a Brown Act lawsuit, you will pay the other side's attorney's fees, as well as you'll be paying your own lawyers. A public entity, by contrast, does not have a right to recover its costs and attorney's fees unless the lawsuit is determined to have been clearly frivolous and totally lacking in merit. I can tell you, having done this kind of litigation for a long time, that's an almost insurmountable standard. It's very difficult for a city to win that standard. Not impossible, but a little bit difficult. Note as well that many cities now are using what's known as the anti-SLAPP statute. Some of you may be familiar with the anti-SLAPP statute, which was brought in really in the land use context years ago. It is now applicable to Brown Act lawsuits as well, and it gives cities some ability to knock out a frivolous or superficial lawsuit without proving that it's frivolous or totally lacking in merit under the other statute at a very early time. Unlike other anti-SLAPP motions, however, the anti-SLAPP statute is clear that cities may not recover their attorney's fees under it. Next slide. Okay, I'm going to move into California's other main transparency statute, the Public Records Act. And I'm only going to talk a little bit about part of it that is frankly more interesting to public officials, and that is what the public is entitled to on your personal electronic devices. Next slide. So the Public Records Act says that all public records are open and public, and the public has a right to look at them. So what is a public record? It includes any writing containing information relating to the conduct of the public's business that is prepared, owned, used, or retained by the agency, regardless of physical form or characteristic. For years, it used to be that public officials, council members, etc., would use their own personal electronic devices, and then the city would argue, well, we don't maintain those devices and we don't control those documents. They are controlled solely by our council members, and we have no supervisory control over our council members. They were limited. The California Supreme Court now several years ago rejected that argument. And it said that potentially all of the communications relating to the conduct of the public's business on your personal electronic devices are potentially public records, irrespective of the fact that these devices are maintained privately. And most cities are developing procedures for responding to Public Records Act requests. And believe me, if you're not already getting them, you will be getting them, where someone is asking for your personal emails relating to city business. And understand that under this case, excuse me, City of San Jose versus Smith, writings about public business are not excluded simply because they have been sent, received, or stored in a personal account. Next slide. The Public Records Act does not, however, include a variety of different exempt documents. I'm not going to go through that list. It is pages and pages long of documents that the legislature has said ought not be disclosed. There is a catch-all exemption for documents that where the public interest in non-disclosure clearly outweighs the public interest in disclosure. And I'll tell you, having litigated lots of Public Records Act cases, that's a very difficult standard for public agencies. So don't expect that we can sort of blithely exempt documents under this broad catch-all exemption. The courts in the reported cases have really put the burden on cities to make a full explanation of how the public interest in non-disclosure outweighs the public interest in disclosure. It's very seldom that is the case. Next slide. Okay, Brown Act during COVID-19. We're dealing now with what one of my colleagues calls virtual reality, conducting meetings openly, publicly, and online. Next slide. There have been a variety of different, as you know, different emergency executive orders that the governor has issued. The statutory basis for that is in the government code in section 8571. Effectively, it says the governor may waive regulatory statutes in an emergency. There is and has been litigation as to whether the governor's executive orders have exceeded the scope of that authorization here, but so far the courts have not ruled that the governor has exceeded that scope. Initially, the first of the orders that came in that the governor issued relevant to what we're doing was Executive Order 2520. It suspended the Brown Act to allow members and staff, members of the agency and staff to attend meetings by phone. But it said, but the agency still had to provide a location for the public, a public open location. I think pretty clearly, at least within 5 days, by March 17, the governor realized that was not going to be a good idea consistent with public safety. And the second order came out, Executive Order 2920. It basically suspended 2920, suspended 2520 to withdraw the requirement for a physical location. And finally, 3520 suspended parts of Government Code 54952.2, Brown Act, to allow collective briefing of city council members outside of a properly noticed meeting. But did not allow for deliberation by the council members. Next slide, please. So 2920 is what allows us to do what we're doing now and allows you to be conducting your meetings virtually. Excuse me, I need a quick drink. Um, 2920 allows public meetings to be held by video, teleconference, or other electronic means during the period in which health officials have imposed or recommended social distancing. It suspends numerous other Brown Act requirements, including the requirement to identify the physical location of members participating by teleconference. You'll remember that I talked earlier about the fact that the Brown Act allows teleconferencing, but only under pretty strict circumstances. This allows it, and under pretty relaxed circumstances. Suspends the requirement that we identify the physical location of members, the requirement that we post agendas at each teleconference locations. You can see the the public safety and the COVID basis for all of this, and for the requirement for a quorum of the legislative body's members to be within the jurisdiction when the meeting is taking place. You'll remember that normally when we're not dealing with COVID, only one or two members may teleconference at any one time, and typically you have to have a quorum within the city. That's not the case under COVID Order 2920. Next slide, please. However, not everything has been thrown away. 2920 still requires cities to provide advance notice of and post agendas for public meetings in accordance with the Brown Act's timeframes, provide information by which members of the public may observe and offer public comment, and advertise and implement a procedure for receiving and resolving reasonable ADA accommodation requests. Next slide, please. So in addition to our public meetings, there's a difference when you have a public hearing. And I've alluded to that a couple times here with respect to your adjudicatory decision making. When the city is acting as a judge, and typically, as I said, that's on a CUP, some kind of a map request, a lot line adjustment, or a tentative map, or other decisions that you'll have under your code, architectural review, like that, are typically considered to be adjudicatory decisions where you're acting as judges. There, you're required to conduct what's called a public hearing, and that's different from a public meeting. There are also situations where you're adopting taxes and fees where you have to conduct public hearings. Public hearings require as I said before, a bit of due process. Essentially, the idea is that they have to be fair. They have to allow stakeholders to say their piece such that their rights won't be impinged without there being a certain constitutional protection. So Executive Order 6320, recognizing again that public safety didn't allow our normal public hearings where everyone gets together in a room, it suspended the normal rules. And it says any statute or regulation that permits a party or a witness to participate in a hearing in person, or a member of the public to be physically present in a hearing, all of that is suspended, provided that all of the following are satisfied. Britt, next slide. 1, each participant in the hearing must have an opportunity to participate in and hear the entire proceeding while it is taking place, and to observe the exhibits. 2, a member of the public who is otherwise entitled to observe the hearing is entitled to observe the hearing using electronic means. And 3, the presiding officer, the mayor, or the chair of your planning commission, satisfies all requirements of the ADA and Civil Rights Act. And that's something you'll have to coordinate with Britt and your city attorney on. The point here is that under this executive order, the governor has recognized that city business and city public hearings have to continue, but they have to continue in the era of virtual meetings under COVID. I can tell you that there is litigation statewide. There are stakeholders who don't like virtual meetings, who believe that witnesses have to be able to look in the eyes of their opponents at the meeting, and the absence of that is a deprivation of constitutional due process. So far as I know, no one has won that argument, and it'd be hard for me to imagine a judge in an era of public safety and COVID ruling that is required, that actual in-person physical gaze into my eyes requirements have to be satisfied. Next slide. Okay, briefly, I alluded to this before. A recent statute, AB 992, that became effective this month, it amends the definition of the term meeting, and it deals with the ability of public officials, consistent with the Brown Act, to use social media. It clarifies that communications that officials can, that some of public officials' communications can violate the Brown Act, but they can also take place. And the legislature, in its infinite wisdom, has told us what those are. This new law, AB 992, includes platforms such as Facebook, Instagram, and Twitter. It also applies to chat rooms and forums, comment selections on blogs and online media. Next slide. What it tells us is that some social media interactions are specifically permitted now by the Brown Act. Remember before I said that that was a bit up in the air and it was an area that you ought to be cautious about. The Brown Act now says that you may have social media interactions. However, a majority of the legislative body may not use social media to discuss agency business among themselves. New slide. Now, this includes, what does it mean to use it among yourselves? It means commenting, replying, sharing, reacting, or using digital icons, such as emojis or GIFs, or, as I said, the like, or the fireworks going off in response to something somebody has posted, is not okay. What AB 992 says you may do is answer questions from the public. You may provide information to the public, and you may solicit information from the public. Next slide. So AB 992 says you can communicate on social media, but you should not directly respond or react to anything posted or shared regarding agency business by even one other member of the same legislative body. Next slide. So typically under the Brown Act, as I've said before, two of your members of the council or two members of your planning commission perfectly appropriately may converse about a topic of city business, as long as it's not a majority and as long as you're not using a serial meeting, as I've described it, to include a majority. Less than a majority may talk about business. That's not the case on social media anymore. So be cautious if you're on social media and one of your colleagues invites you to respond in some way, even if it's just to hit the like. The Brown Act now prohibits that, and you may be facing some liability under some of those remedies that I discussed previously. Next slide. Hey, that's it. I am here to answer questions. I've seen, I think, that some written questions have come in, but let me see if I can. Yeah, I'm not sure how to look at the written questions. So if any of you have questions, I'm here for as long as you need.
Go ahead, Donna. Donna, you're muted.
Being responsible, if a commission or the council is sued for a violation, does the city represent them in a civil suit, or do they, for the city portion of it, are the individual responsible? And if so, do we have any insurance, homeowners, or any insurance that would pay for any legal fees?
Well, you really put me on the spot there. Let me tell you this, that Donna, I'm sorry, are you on the council?
No, I'm on a commission.
Okay, so that's a very complicated question that goes into questions about when and under what circumstances the city represents its volunteer members of boards and commissions. The short answer is that in almost every situation, the city will represent you if you're sued in a civil lawsuit along with the other members of your commission. That's not always the case, and you're going to need to consult with my colleague, with your city attorney, if and when you ever get sued under the Brown Act. I can't advise you at all as to whether your homeowner's insurance or any other non-city, coverage would cover your representation there. But I will tell you that I've been representing cities for, as I said, for nearly 40 years, and we almost always represent the individual, volunteer board members in these kinds of cases, unless there is something that would be extremely unlikely where, for example, there was an allegation with some evidence behind it that, that your violations were intentional and, not in the normal course of your business with the city as a volunteer member of the commission. Does that answer your question? I kind of dodged it a bit.
But on top of that, if you're a council member and you do not recuse yourself, or if you're a commission and you do not, and later they find that you did have an interest, even if you didn't rule badly, does the council have a problem with that then?
I'm getting a little hypothetical, but yes, where you've been advised by your city attorney that you ought to recuse yourself, or that there has been a violation and you continue to violate even in the face of that advice, that can create problems for you individually.
Thank you.
Jeff, did you have a question?
I think you're muted, Jeff.
You're muted, Jeff. I had to mute you. There was some background noise coming, and now he's gone. I'm sure he'll be back. Are there any other questions? There's Jeff. Looks like he's coming back on. You're muted though, Jeff, just so you know.
His question is in the chat box, Britt.
And he just left again, so we can't answer it.
It says,
I know, Sarah, I know, but we don't want to answer it until he comes back.
Okay.
There he is.
Like he might be having issues though. So once we know he's here, Jeff, you're muted. There we go.
Not muted anymore, so
There we go.
thank you for bearing with me. First, Mr. Brown, I'm a member of the council, and thank you so much for giving us this presentation today. I know I very much appreciate it, and I'm sure everyone else on the call does too. We really benefit from your firm's representation of us. Mr. Pierick is an excellent lawyer, so thank you for all of that. I see that my question has sort of gone away from the chat room, so I'll try to rephrase it again. In the past, before COVID, Britt's practice was to print all of the emails that we receive on issues and have them at the dais for people that are at the meeting to examine if they so choose to. And now that's a bit of a problem because obviously there's no dais. What should we be doing to, people that send emails to the council or to one of the other bodies, what should we be doing to provide those emails to the public either before or during a hearing?
Well, that's a great question. And the answer I would give, and I would defer to Britt to a large extent here, and it'd be great to have Brian here, but my take on what the executive order envisions and requires is that we do the best we can do to have the virtual meeting be a lot like a regular meeting. In other words, to be as open and transparent and to allow as much public participation as we can do, consistent with the limits on staff and the limits on our electronic media. And so I don't know what you're trying to do with that, but what I advise is try to do as much as you reasonably can do to make your processes now like they were, and to allow the public to have as much participation. I'm getting a lot of feedback. Anyway, I think I'm repeating myself, but there is no bright line answer to that, Jeff. And I'm just saying that the best practices that I'm seeing are when agencies are doing the best they can. I guess that's the way I would put it. I think I would be able to make that case well in court.
Okay, thank you very much.
All right, does anybody else have any questions for Tom? Tom, that was great. Donna, again, you have another question? You're muted.
I think you're muted,
Donna. Yeah, you're still muted, Donna. There we go.
That was one of the nicer ones I've attended.
Oh,
thank you.
Great. Yeah, this was good. Really, really good, Tom. Thank you.
All right, all. Good seeing you. Stay well.
Thanks. You
Thank
too.
you.
We'll talk soon.
Bye-bye.